Good morning and welcome to this webinar. My name is Susan Barker. I'm a Senior HR Consultant, part of the Alchemist PSM HR Consultancy team, and I've been with the company for 16 years. If you have any questions, please ask them using the question panel on your screens, and I will answer them at the end of the webinar. So the subject of today's webinar is employment law changes. And I will be looking at what employment law changes there are, why the changes have been made and introduced, and also looking at ways you can ensure your business is up to date and ensuring that you are fully compliant. So let's start by looking at increases to payments. As most employers are already aware, each year there is a review of statutory payments, and this year is no exception. There are 3 dates in April to be aware of affecting a number of statutory payments. First is on the 1st of April, when the national living and minimum wage payments increase as follows. Apprentice rates increase to £3.90 per hour. Under 18 years of age increases to £4.35. Aged 18 to 20 increases to £6.15. Age 21 to 24 is £7.70, and finally is the over 25 years of age at £8.21 per hour. The next date that is applicable is the 6th of April, and the first payment change to be aware of is the lower earnings limit. This is an important amount to be aware of, as this is the rate of pay an employee has to achieve in order to qualify for any other statutory payments. So the lower earnings limit increases to £118 per week. Statutory sick pay increases to £94.25 per week. Statutory guaranteed pay increases to £29 per day. The maximum statutory redundancy pay increases to £525 per week, and the unfair dismissal cap at an employment tribunal increases to £86,444. Finally, in relation to statutory payments are the family-friendly areas, and the effective date for these increases is Sunday, the 7th of April. The following payments will be affected: maternity pay, paternity pay, adoption pay, and shared parental pay. And the weekly amount increases to £148.68 per week. You may be wondering why there are so many employment law changes planned. The main reason is that the government commissioned the independent Taylor Review, which was published in 2018. This was widely reported on in the media, and as a result of this review, the Good Work Plan was introduced, and this is where much of the legislation change has come from. The Taylor Review was commissioned to look at ways to address the changes and challenges of the ever-evolving world of work in today's economy and environment. So we will explore some of these changes through the webinar. Some of the changes take effect from April 2019, and some are April 2020. So let's work through them in chronological order and start with the important area of pay slips. Whilst most employers will already be aware and hopefully compliant that you are legally required to provide your employees with a pay slip. However, with effect from April this year, this right extends to workers too. A worker can include people such as agency staff, bank and casual staff, and also zero-hour staff too. Looking into a bit more detail as to why this change has come about, I've already mentioned the Taylor report being commissioned to look at the changing world of work. And what it has identified is something that is referred to as a gig economy worker. This is not just about workers in the music industry, but those that I have already mentioned, such as agency, casual and bank staff. And generally speaking, it refers to those workers who arguably may have been subject to exploitation, especially in relation to areas such as low pay and excessive hours. Employers should ensure that all workers and staff receive their pay slips on or before their scheduled payday, be that weekly or monthly. In addition to now having to provide all staff and workers with a pay slip, the legislation changes also stipulates that pay slips need to be itemised to show the number of hours that have been paid, particularly when the worker is hourly paid. Hours worked can be shown either as a single total number of hours in the pay period, or can be broken down into separate figures for different types of work and or different rates of pay. So by providing all workers with such a detailed itemised pay slip, it will make it easier to check that everyone is receiving at least the national minimum wage. Pay slips can either be in electronic or paper format, but what is important is that it is clear and transparent what is actually being paid. So what do you have to do to make sure you are compliant? Determine if you have any workers who are not receiving a pay slip, so you need to know who is on your payroll. Are your systems able to produce itemised pay slips? And do your systems actually record the number of hours that your workers are actually doing? If you are unsure if someone is a worker and therefore should be getting a pay slip, the Alchemist PSM HR consultancy team can offer you guidance and advice on this. A further change is in relation to employment tribunals, and this is effective from next month too. There is quite a substantial increase to the maximum penalty for what is known as an aggravated breach of employment rights. This is increasing from £5,000 to £20,000, so it's a quadruple increase. An aggravated damage is not something very clearly defined in legislation. However, there is a suggestion that an employment tribunal may be more likely to find an aggravating feature if an action was deemed to be deliberate or committed with malice. Consideration would also be given to if the employer has a dedicated HR team or HR support, or if the employer has repeatedly carried out the breach. Thankfully, this is a fairly uncommon aspect of any employment tribunal claim we at Alchemist have had to deal with, but it is worth being aware of, as it should encourage you to act upon any grievances, complaints or concerns brought to your attention in a swift and timely manner, as this could help to reduce the risk of any repeated actions taking place. Other aspects of the Good Work Plan come into force in April 2020, but now is a good time to start thinking about and preparing for them. So let's look into the future. Written statements of employment is the area I'd like to cover now, often referred to as a contract or a contract statement. Currently, legislation states that an employer should issue a contract within 2 months of start date. This is regardless of whether or not someone is on a probationary period, and this is a fact a lot of employers can be confused about. However, this confusion will be eliminated as in April 2020, the written statement of employment must be given from day 1 of employment. In addition to the deadline for issue changing, the update also means that some specific information must be contained in the statement. And this includes information relating to working hours, probationary periods, details of any training provided and that is required to be completed, along with information as to who pays for such training, sick leave and pay entitlements, and all other rights to leave, such as maternity and paternity. As is often the case with new or updated legislation, the finer detail is released much closer to implementation dates, and on occasions has been afterwards or even determined by case law. This is the case here regarding this piece of legislation too, so we are yet to fully establish if the current practice adopted by contracts drafted by Alchemist needs to be changed or not, as the details I've just mentioned is already referred to within the employee handbooks we provide, and this does form part of the contracts of employment for our clients. There is even a clear caveat in the contract statement saying that employment is subject to the terms stated in the handbook. So we await further guidance in this area. But in the meantime, what else can you be doing? Start now. Get into the habit of issuing contracts on or before day one. Doing so does not affect your ability to consider short service dismissals or performance management of any sort, or even to have a probationary period. Consider sending out the contract statement with your offer of employment letter. That way, your prospective employee has full disclosure on their terms and conditions. Think about your induction process, or if you don't have one, introduce one. An induction is an ideal time to exchange information with a new starter, including giving them their contracts and explaining what your rules and procedures are. Staying on the subject of contracts, come April 2020, a worker, and remember this means but isn't exhaustive of, agency, bank and casual staff, they will have the right to request a more predictive and stable contract after they have completed 26 weeks of service. Once again, guidance is sketchy on this topic. So whilst we know right now that there will be a right to request such a contract, as it appears at the moment, this is just a request. It doesn't mean that there is an automatic right to have that request granted. But again, we have to wait to see. The final aspect in relation to contracts I will cover is in relation to continuity of employment and breaks in service. This is a question we come across often on the HR advice lines and is a grey area. However, this will become much clearer as the legislation will dictate that any breaks in service must be 4 weeks or more to actually cease the employment being continuous. So what should you be aware of? Well, you need to take into consideration that an employee may obtain continuity of service even if they have gaps in their employment record of up to 4 weeks. Danger areas related to this will be when you are considering a short service dismissal for an employee of 2 years service and under. So to protect yourself regarding this change, our best advice is to ensure that you keep accurate and clear data on your staff in order that you can see any start dates and assess if those gaps will affect continuity. Finally, in relation to contracts, if you feel you need assistance in drafting, reviewing or updating your contracts of employment, again, the Alchemist PSM HR team can assist and support you with this, and also ensure that you are currently compliant and ready for the 2020 changes. So please do make contact with us. Another major change coming into force in April 2020 is in relation to holiday pay. If you currently employ workers on varied hours, you will already be using a 12-week reference period to establish their earnings for things such as holiday pay purposes. In April 2020, the 12-week period increases to 52 weeks. If a worker has less than 52 weeks service, you must use the actual number of weeks worked. This change will ensure that workers who do not have a regular work pattern throughout the year are not disadvantaged by having to take holiday at quieter times when their weekly pay may be lower. So again, thinking ahead, you might want to think about reviewing your finance and account software, make sure that you're able to cope with the increase in data you'll need to have readily available. If you outsource your payroll, start to talk to your provider. Hopefully they will already know of this change, but worth checking with them and ensuring that they are ready for it and also able to cope with the new calculations. I'd now like to just touch on agency workers. As some of you may already know, the agency worker regulations were introduced back in 2010. Part of the Good Work Plan means that there are some changes to the legislation, and this will include that an agency worker will have the right to be provided with a key facts page. This fact page will need to include information on their type of contract, their rate of pay, and who is responsible for paying it, along with information regarding any deductions or fees that will be made. In addition to this change, the Swedish derogation of the regulations is to be abolished. This is part of the regulations which has affected pay parity. So in other words, all agency workers will have the right, after 12 weeks of service, to be paid at the same rate of pay as the staff employed by the company they are assigned to. Finally, in relation to employment legislations, although there are no planned or proposed changes to the family-friendly entitlements, such as maternity, paternity and adoption, there is, however, a new piece of legislation coming into effect also in April 2020. This is the Parental Bereavement Leave and Pay Act. This means that all employed parents will be entitled to 2 weeks leave if they lose a child under the age of 18, or if they suffer a stillbirth from 24 weeks of pregnancy onwards. Employed parents will be able to claim pay subject to certain criteria, and the leave can be taken in one block or 2 separate blocks, and can be taken within a 56-week window. This has been purposefully introduced in order to allow time off for moments such as anniversaries, when it would be difficult for the parent to be at work. On a final note, I will just touch briefly on Brexit. At the time of preparing this webinar, the UK has secured an extension to the deadline of the 29th of March for the UK to leave the EU, but there is still no decision on deal or no deal as yet. So moving forward, even if the UK has the opportunity to diverge from EU employment law, changes may not be immediate at the point of Brexit, because much of EU employment law has been brought into effect via UK legislation anyway, and it will therefore remain in force unless it is either amended or revoked. Additionally, many UK employment rights, including unfair dismissal and minimum wage, do not stem from the EU. Also, in some cases, the UK provides protection which actually exceeds the EU minimum, things such as maternity leave, and also the right to 5.6 weeks holiday per year is in excess of the EU, which is only 4 weeks. So although there are no set changes in legislation we know, purely spectacularly, there may be an opportunity for the UK to amend some areas of employment law, and if we were to take an educated guess, we would suggest that areas for review could include there being the introduction of a cap on compensation for discrimination, which is currently uncapped. There may be an amendment to TUPE, which is the transfer of undertaking regulations, to perhaps make it more business friendly. Arguably one of the most contentious areas of legislation is the accrual of holiday pay whilst on sick leave. And finally, maybe the removing of the 48-hour cap on the maximum working week. However, these are just our thoughts here in the Alchemist HR team, and we all just wait to see what will be developed. To help ensure you are ready for the changes in 2019, we have created a gap analysis for you to download and to identify any areas for improvement. This will be emailed to you along with a recording of the webinar. So thank you for listening to the webinar, and I'll now pick up on some of the questions you have raised throughout. Okay, one question we've had is in relation to the aggravated damages information, with somebody just asking to give an example of what aggravated damages actually are. Yeah, as we've said, it's fairly uncommon, thankfully, but an example would be if you've got an employee who makes a claim or a grievance of some kind to say that they've maybe feel harassed, be it racially, sexual harassment, and they believe that this is ongoing and you as the employer haven't dealt with it appropriately and it's continued. If you've not carried out a formal investigation or taken any action and the harassment arguably continues, that would be a claim for discrimination and harassment, and the aggravated damages aspect would be because you haven't acted upon it and you've allowed it to continue, which would be contrary to the Equality Act 2010. So it would potentially increase any compensation and damages awarded. So this is what I mean about acting on things as soon as they're brought to your attention. Another question we've had is about the breaks in service, with the question being if the 4 weeks continue is applicable from the actual exit date itself. Where legislation sits with this is it currently says that the minimum of 1 week ends on a Saturday. So in the absence of there being any further changes to this guidance, what we will be saying is that the 4 weeks has to end on a Saturday. So it's not necessarily on the last working day. You have to start the clock ticking from the Saturday. I think a final question we've got here is on Brexit, asking about the settled status, asking if there is a deadline that we're aware of, and also if there's going to be any fees still in place. As we mentioned on the Brexit slide, things are obviously still up in the air. We're not quite sure where things are heading. Theresa May did say come January 2021 that there is going to be an overhaul, meaning that there's going to be some changes in relation to settled status. But as we know at the moment, the EU settlement scheme, as far as we're aware, will be fully open on the 30th of March, so not long for that. And the deadline for applying for settled status will be running up to the 30th of June 2021. The Prime Minister has announced that there will be no fee when the scheme does open, and anybody that has already applied and paid a fee during the test phases, they will be entitled to a refund. So as we're aware at the moment, the answer is the deadline will be up until 30th of June 2021, and there will be no fees. That's all the questions that have come forward. So I'd like to just round this up by thanking you once again for watching. I hope you found it useful. We will be sharing a recording of the webinar materials with you shortly after. And finally, to help us improve our webinars, there is a short questionnaire at the end. It'd be really helpful and grateful if you could complete that for us. And thank you once again.